Hello everyone, my name is Venkatesh Gaikwad and today I will be presenting on the topic of the judicial reforms and establishment of high courts which happened just after the Regulating Act of 1773 from the years 1783 till 1795 and its impacts. So, judicial reforms of Cornwallis, which happened after a few years after the Regulating Act and the Act of Settlement was passed in the year of 1787. Lord Cornwallis introduced a significant changes in our entire judicial system that was existing at that time. So he passed judicial reform in three terms in 1787, in 1790 and 1793. In three terms he has passed judicial reforms. So in his first terms he has separated executive and judicial powers. That is, he has appointed a collector who will deal with specifically executive functions, that is collection of revenue, and established district courts as well for taking up civil matters. So he has clearly established a difference between executive functions of revenue and judicial functions of civil cases in nature. Then appointment of European judges. So till now many lords that were existed, many English officers existed, used Indians to perform their function in the judiciary. But what Lord Cornwallis did is he appointed European judges to ensure that there shall be impartiality. What is happening is when English people are there, they will favor English people. When Indian judges are there, they will favor Indian people in the case or disputes. Therefore, he neither invited Britishers nor Indians. He invited European judges to ensure that there shall be impartial delivery in the justice system. Then codification of laws, standard laws that were existed, that is criminal procedures and civil procedures, were codified in nature, because till then only oral laws were there, only on equity, justice and good conscience they were delivering the justice. Then in the second plan, looking at the problems of the first plan, many reforms were focused on criminal system. So first plan only focused on the civil system, but this plan focused on the criminal system. So in this plan, circuit courts were established to reduce the backlogs of criminal cases. So this is another alternate or a different mechanism from our traditional system to establish circuit courts, which will then reduce the burden of our judiciary at that time. Then sessions court was also first time was introduced. So sessions court, criminal court and circuit courts, these three courts were working simultaneously together to reduce the backlog of criminal cases that were existed at that time. Then again criminal laws were also codified in this regard. In the third plan, the final phase of the judicial reforms done by Cornwallis is aimed at consolidating the judicial authority that was existed at that time. So he introduced collectors as judicial officers. So he increased status of collectors and merged the revenue and judicial role for efficiency. So in the first plan itself, he has divided the role, but as the plans are progressing in this third final phase, he merged the revenue and judiciary functions and gave collectors the discretionary power as judicial officers. And he enhanced the appeal process and allowed higher courts to review decisions. So appeal process was already there, but he enhanced this appeal procedure that was existed before and gave it a more importance. And last feature is implementation of procedures. He established centralized legal procedures across courts. So what is happening is, before there were no codified laws, but after these three reforms of Lord Cornwallis, he codified both civil and criminal laws for better functioning of a judiciary. Then what are the impacts of the reforms that the Cornwallis has brought? So what are implications of that said judicial system at that time is it strengthened the rule of law. Because when rule of law prevails is only when the laws are in a codified format. Before, the laws are not in a codified format, which is the reason why they are not able to be enforced properly. But with Lord Cornwallis bringing both civil and criminal matters in a codified law, due to this, the strengthening of a rule of law prevails. And then increased efficiency, as he emphasized more on appeal structure that was existed at that time. He established a streamlined procedure, due to which efficiency of the courts, of the functioning of the courts, increased by a lot. Then development of a legal framework. Again, we are seeing that how Lord Cornwallis implemented from the Act of Settlement till his final phase, he has clearly established proper Indian law in our India. And last point is judicial independence. So we have seen in the very first plan in the 1787 that he divided the functions of both revenue, that is executive, and judicial. Next is what are the problems and progress of our judicial reforms from the year of 1793 till the year of 1833, that is almost a span of 40 years. So main problem that existed to till this date is the problem of the backlogs of the cases, because courts are always overburdened with their work, and this leads to delays in justice. Next point is there is a limited legal representation, because all of the people are not going to courts just for the sake, because they fear courts, they fear this procedure, because they think that it will take a lot of time for us to get justice. That's why they don't go to the courts, which is the reason why there is a less legal representation as well. Another reason, that is access to justice remains unequal, that is rich people get justice and poor people doesn't get justice. This is the thought. Last is disparities in our judicial application, that is inconsistency of application of laws in different regions. So in some regions or second tier or first class cities, application of laws is proper there. We can take an example that in white towns, which we have seen earlier, white towns application of law is properly there, but in black towns application law is not properly implemented. So next is the reforms done by John Shore, Wesley, Minto and Bentinck. These people have done or changed and brought many reforms after Lord Cornwallis. So what are the key changes that these governors at that time has done after Lord Cornwallis? First we talk about John Shore. He continued these reforms but struggled with implementation challenges. As we see that giving reforms or giving an opinion is very easy, but implementing the actual thing is very hard, and these challenges he faced, John Shore faced. Next, Wellesley. Lord Wellesley focused on enhancing the administrative efficiency, because if you want to manage the economy of an entire country, you need to properly manage the administrative sector. So Lord Wellesley focused on enhancing the administrative efficiency of India. Next is Lord Minto. Lord Minto introduced consolidated reforms and addressed demands for a quicker justice. His plan mainly talks about how this problem with judiciary always, that there is a backlog of cases, should be solved. Last, Lord Bentinck in 1828, he gave major reforms, and the most important personality which each one of us should know, because he is the one who abolished sati practice and codified that prevention of sati law. He played a very important role in ensuring that people don't get oppressed in Indian society, women don't get oppressed in Indian society. Next is the Charter of 1833. So in the span of 40 years after the Act of Settlement, many changes, many trial and error methods have been done by many people. But when a charter is issued, then clear developments are seen. Many judicial officers come to India, they go back again because they are not able to solve problems. But charters entirely change the process of our entire judiciary. So what Charter of 1833 has given? It has introduced many changes. First is the centralization of judicial authority, that is unified administration of justice. So Charter of 1833 mainly aimed to centralize the entire procedure of judiciary as well as executive on face of it. The Law Commission formation, this charter played a very important role, because the very first Law Commission was formed through the Charter of 1833. Now, Law Commission plays a very important role, as we know, as the condition is right now. Article 13 clause 2 for Indian Constitution states the doctrine of judicial review. Now, judicial review itself is very important. Why? Because it reviews the laws that are passed, and it suggests that whether that laws is interfering with our fundamental rights or not. Similarly, Charter of 1833, which found the Law Commission at that time, established to review and reform the laws which are already existed in our country if those laws are interfering or creating problems for people at large. Next is removal of discriminatory practices. Again, Charter of 1833 sought to establish a more equitable legal framework. Next is what are the defects overall from the year 1793 till the year 1833 after Lord Cornwallis has left. So despite all of the reforms, again the same point has been repeating, that overburdened courts are overburdened to this day. This problem is not yet solved. Even today there is a lot of burden on all of our courts that are existed in India. Then till today as well the same problem, that is corruption and inefficiency of government. There are a lot of issues which affect the credibility of judiciary as well as executive as well as legislature enacting certain law which will favor a certain community gets passed, then again goes for judicial review, certain problem is found but no solution is provided for long periods of time, which creates and leads in inefficiency of that particular system. Next is unequal treatment, because various legal treatment is based on class and caste. Now, in the recent examples that we are seeing, we are talking about many cases where rich people are getting justice as they please. Because rich people have money, they can influence the entire system because they are very rich, and poor people is denied justice. So this is the defects we are seeing to this day. And with this, I have come to an end. Thank you.